All right, this after the first lawsuit has been filed in that Florida bridge collapse. Many more expected. Emily Compagno joins us right now, attorney extraordinaire. Emily, what are you looking at here?
Look, this calls to mind the 2013 Philadelphia Salvation Army building collapse case, and there all 7 principals were held responsible for that fatal collapse as well. And here's why. They exhibited outrageous, negligent conduct that exhibited a reckless indifference to safety and interest of others. And what's important to note there is everyone from the real estate developer to the architect was held liable, and the architect was held criminally liable because he knew the building would collapse and failed to pass along the warning. Now here we have, as you just played, a voicemail of the project manager acknowledging cracking in the bridge, but saying specifically there was nothing to worry about on the safety concern. Courts have held that this level of negligence or this kind of culpability can come along in the form of failing to pass along warnings or even hiring unlicensed or inexperienced subcontractors. So as you said, this is the first lawsuit. We expect many that the courts will likely consolidate, and we are looking at both civil and criminal liability moving forward.
Who is liable?
Discovery phase will illustrate all of that. We are going to find out exactly who knew what and when. And again, even hiring someone inexperienced or unlicensed to knowing that there was a crack, but refusing to admit that it's a safety concern, those are things that can be either rising to the level of civil culpability or criminal. Or even the ghost ship fire in Oakland, right? We had the manager that was held criminally liable. So was PG&E because they knew or should have known. So that range of culpability can really extend to numerous subcontractors, including the developer.
What about a public, like a government entity? You know, whether the
right.
city of Miami or what have you. How far does that extend?
Exactly. That depends. It has to pierce a certain sovereign immunity if it's a public entity, right? So if there's an element of negligence that was proven to such to pierce that immunity, they can absolutely be held liable, but they have a higher bar to cross than, say, the project manager or the architect. But again, courts have held everyone involved in these kinds of fatal, terrible tragedies can be held civilly and criminally liable.
If, for example, they could prove the fact there was a crack, someone would have been warned about the crack, and all these other things that could reveal, had someone done something then, it would have been avoided.
Exactly. And note that juries will figure out the apportionment, right? So they may say, well, this guy who left a voicemail and refused to acknowledge a safety concern, he's going to be 60% liable and 20% liable to the guy who should have known but didn't, right? So they kind of apportion that out in terms of who they feel is the measure of responsibility shared. It's not just one.
All right, Emily, thank you very much. Emily Compagno. All right, a quick final look at the